file number 255058. The record should reflect Mr. Warner is present here in the courtroom today. Mr. Travis, how did you want to proceed with this file?
Your Honor, it's my understanding that Mr. Warner would like to accept the plea offer from the prosecutor. My understanding of that offer would be that if Mr. Warner pled to an attempt on count one, an attempt larceny in the building, the prosecutor would dismiss the habitual offender notice, and obviously count one is a 4-year, his attempt to be 2 years.
Mr. Ziegler, is that a correct statement?
Brian, yes, the people, that's a correct statement.
Okay. Mr. Warner, have you had an opportunity to speak with Mr. Travis about this plea agreement?
Yes, sir.
And is that how you wanted to proceed today?
Yes, sir, I do.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Warner, are you currently on any kind of probation or parole?
Yes, sir.
Is that here in Calcasieu?
Yes, sir, it is.
All right. And do you know whether you're going to face any additional penalties for violating your probation?
No, it was because this happened before.
Oh,
So yeah, talked to my PO. He said he wasn't gonna violate it or anything like that.
okay. And then as an attempt larceny, this maximum penalty, possible penalty would be up to 2 years. Do you understand that?
Yes, sir, I do.
With that in mind, what is your plea to that charge?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you have to ask for the Court of Appeals to hear your case. If they said no, then you wouldn't be able to go any further with that appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir, it is.
Are you pleading guilty because you are actually guilty of this crime?
Yes, sir.
The information I have indicates this happened back on December 5th of 2024. Is that the correct date?
Yes, sir.
And on that date, did you enter into a residence or a dwelling here in Calcasieu County?
Yes, sir.
And did you take some money or property from that residence?
Yes, sir. It was prescription pills.
Okay. And did you have any permission to take those?
No, sir, I did not.
And was it your intent to take those and put them to your own use?
Yes, sir.
Mr. Ziegler, are you satisfied with the factual basis?
Yes, sir.
Mr. Travis?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, sir.
Mr. Travis?
Yes, sir.
Mr. Warner, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. Court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Travis prior to that so that you're prepared for that hearing. Ms. Wagner, did you want Mr. Warner to stop by your office today?
Yes, please. Thank you.
So after you leave court here, Mr. Warner, make sure that you go across the way to the probation department, okay?
Yes, sir, understood.
All right. Do you know what case the AG is appearing on?
Eric Ross.
Yeah.
Okay. No, everything I've been talking with probation, everything on this is good.
It's all good news.
Wonderful.
Okay, so we'll go on the record in People versus Nichols. This is file number 234827. The record should reflect Ms. Nichols is present here in the courtroom. If I could have counsel here.
Brian Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mrs. Nichols.
Okay, this is date time set for a hearing. Ms. Nichols, you were originally sentenced to participate in the sobriety court program. I received notification that you successfully completed that program, and that everything but the late fee has been paid, which the court will waive. So you're fully paid up. You fully complied with all the conditions that you were required to comply with when you were sentenced back in November of 2023. Mr. Ziegler, do people have anything they would like to say here today?
Yeah, I'm sure Ms. Nichols would agree that 2 years goes by very quickly when you're in the sobriety court program. It just seems like yesterday that Ms. Nichols joined the program, and she's already graduating. She's done very well in the program. Little or no issues the entire time she's been on the program. I think she would tell you that she's benefited a lot from the program. She's one of the last ones that will be graduating from the program. So I have nothing but positive things to say about Ms. Nichols. She's fully earned her reduction to a July 2nd.
Thank you, Mr. Travis.
Just that it's a great one that works out this way. I'm very happy for Mrs. Nichols.
Anything you wanted to say, Ms. Nichols?
I just feel it was a really beneficial program. It was a huge godsend for me, absolutely. And I just really appreciate the ability to be part of it, as I know it was ending for you guys here. So just thank you for everyone for allowing me to participate. It was really special for me to be able to do that, and for my kids as well. So just thank you very much for allowing that for me.
It's not a very easy program. I was the presiding judge for a number of years over the sobriety court program, and I know that it's a challenge. There are a lot of restrictions. There's a lot of requirements, and it's not something that people are successful at because they've been ordered to do it by the court. They're successful at it because they truly want to make change in their life, and they embrace it, and they incorporate it into who they are. And you've obviously done that. And so I think congratulations are in order to you, because it is not an easy thing to do. And it's not an easy thing to make that kind of change internally where you want to make that change in your life. And so I congratulate you on that as well, probably more importantly, for yourself, for your family, and really for our entire community, because now we have somebody who's going forward in a much better position to be successful, to be a contributing member of the community, which is what we all want. So it's great for you personally. It's good for us as a community as well. And so I appreciate your efforts and everything that you did over the past 2 years to be a success. And I hope that gives you a lot of confidence going forward. And I wish you the best of luck. And thank you. So, good luck to you going forward. You're no longer under the jurisdiction of the court. I'm going to sign the order discharging you right now.
Thank you.
You are free to go.
Awesome. Thank you so much.
Thank you.
That hearing had a little bit of everything. And People v. Jacob Warner. We watched a textbook example of how plea hearings are supposed to go measured, respectful, and with all parties pulling in the same direction to resolve a matter efficiently. Judge George Mertz once again kept everything calm and by the book. Even as we moved through some fairly serious charges, Mr. Warner came into court ready to accept a plea deal. He'd plead guilty to attempted larceny in a building, a reduction from the original charge. Under the agreement, the initial habitual offender notice would be dropped, reducing the potential sentence to a maximum of 2 years. Both the defense, led by Mr. Travis, and the prosecution, represented by Mr. Siegler, confirmed the terms and kept things clear for the record. Mr. Warner himself was direct and composed throughout the plea colloquy. No dramatics. Just yes, sir, and no, sir responses that showed he understood the process and was taking it seriously. What stood out here was how clean and uneventful the hearing was, and that's not a bad thing. Mr. Warner admitted to entering a residence back in December 2024 and taking prescription pills without permission, no excuses. He accepted responsibility plainly, and Judge Mertz walked him carefully through his constitutional rights, emphasizing the significance of pleading guilty. The judge also made it clear there was no automatic right to appeal the plea, again underlining the weight of what Warner was agreeing to. You also got a glimpse of a cooperative attitude behind the scenes. Mr. Warner mentioned that his probation officer wasn't planning to pursue a violation since the offense happened prior to his probation. It's the kind of detail that shows how all the gears of the justice system, court, counsel, probation can align when everyone's focused on resolution rather than confrontation after the plea was accepted. Judge Mertz set the case for sentencing and reminded Mr. Warner to stay in touch with his attorney and check in with the probation department. A small moment, but one that reinforces how important those follow-through steps are. In a system where people can easily fall through the cracks, this kind of reminder can make a big difference. All in all, it was a clean, professional hearing that reflected a process working as it should. No outbursts, no tension, just people doing the work, and one defendant owning up to a bad decision with hopes for a better turn at sentencing. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.